I've been asked more than a few times, what is an assault? And people get it confused with a battery, but an assault is simply a threat to do physical harm to someone. It's a misdemeanor, really in its most basic form. Now, to understand an assault, I'm going to start this video with some boring technical stuff, the stuff we had to memorize in law school, but you're going to see some loopholes once you hear the definition. So an assault is an intentional, unlawful threat by word or act to do violence, coupled with the apparent ability to do so. And you've done some act that creates a well-founded fear in the other person that violence is imminent. And that violence is imminent is super important. So I've got a lot to unpack here. Let's break it down for you. 3 things make up an assault. First, you have to have an intentional, unlawful threat. Second, you must have the apparent ability to carry out the threat. And third, the threat must create a well-founded fear that violence is imminent. It's going to happen, and it's going to happen right now. So to understand all these moving parts and how they work, we're going to look at the conviction of a juvenile in HWV state. So, juveniles get a little mouthy. They have a lot of assault cases out there. HW was convicted of assaulting a school administrator. He called a middle school administrator a B word. He shouted, F you. And HW is just a middle schooler. And I'm not sure anyone in middle school, gets paid enough to put up with this. We know that. But HW even comes back to the middle school later that day and tells her something bad's going to happen to you today, and you're going to die today. He even claimed that he was going to make sure that she got put to sleep. So, again, this is middle school. This assault conviction, he was convicted, but the conviction got overturned really because of the third element. The appellate court said, look, HW never said the violence was imminent. The threats were vaguely going to happen sometime that day. So it's hard to believe that what HW told this administrator wasn't some sort of crime, and maybe it was, but it wasn't an assault. We should unpack that third requirement that you got to create a well-founded fear that violence is imminent. And we're going to look at a case called Davis v. State. Davis was convicted of aggravated assault with a firearm because he threatened a 1.5-year-old child with a gun. After the incident, the child was screaming, crying, but was this a legitimate conviction for ag assault? And the appellate court didn't think so. They threw out Davis's conviction because they said the state never proved that the child was really crying because of the gun threat versus crying because kids cry. Again, Davis was probably maybe guilty of child abuse. Maybe DCF should take away the kid. I get all that, but was it an ag assault? No, it wasn't, and it was thrown out. So, as you can see, people say it's just simple assault. Well, there's nothing really simple about assaults these days. Get yourself a good attorney. Make sure that you're defended well. Take care.